Dan said, I'm Heather Harris, and I graduated in 2006, and there's been some talk about the 2001 DNA statute, and I just wanted to clarify that statute, that idea for that statute was actually brought to SWAP, the Statewide Association of Prosecutors, from another University of Utah Law School student, and his name was Matt Boyden. And subsequent to him pitching this idea to SWAP is when Professor Frankel came in and met down with SWAP, and ultimately the discussions were held, and obviously that statute was enacted. So I am trying to walk in his footsteps and kind of trying to do the same. A lot of people ask me what gave me the idea to start down this path that I started on, which I really did not expect to go this long when I first started down it. I expected to give a pitch to someone and a heartstring story, and they would sign off and be on board, and I was quickly disillusioned, and I was shown how very naive I was very quickly. It all started in my seminar class that I was required to take, and I was required to take the seminar class, but I chose to take Professor Medwed's class. And that was in wrongful convictions. And part of that class, we obviously learned why wrongful convictions happen in the first place. And as part of that study, we also learned about status of compensation statutes across the country and where the status is of that. We talked about the reality of post-exonerate life, and it's quite different than what I think the average person would assume it is, and I'm going to lump myself in there with the average person because I had no idea how dismal it was. Katie spoke on some of them, so I won't belabor them, but mental and emotional disorders, your general health has decreased, loss of family, friends, due to death, alienation. You miss your kids growing up. Some of these individuals have lost their kids while they're in prison, and many of them have grandchildren that are grown and they've never met them. Also, they have no place to go. Katie was touching on this as well, and during my pitch to the legislators, I compared an exoneree getting out of prison versus a parolee getting out of prison. And at that time, a parolee actually received some walking money, for lack of a better word. They also received a bus trip. They received a set of clothes. Exonerees don't receive that. They receive nothing. A lot of times they don't have any place to go. They don't have shelter. They don't have money. They don't have seed money. Bruce Goodman didn't have underpants. So they really have nothing, and that really paints the backdrop of how important it is to have a compensation statute. Otherwise, as other panelists have mentioned, that the only recourse they have is to sue, and the last thing that these individuals want to do is enter the courts again in a contested, heated battle trying to put the crowbar into the state's budget and get some money. Most importantly is the fact that these individuals have an extremely difficult, if not impossible, time finding a job. And it doesn't matter what kind of job it is, even minimum wage, they can't find it. A lot of it has to do with the fact that they've been in prison for many years, and so they have a huge gap in their work history. I think interviews are uncomfortable as it is, but going into an interview and having to explain a 12 to 15-year gap in your resume and say, hey, I was down at the point, not exactly the way to start off on a really good foot. Also, the fact that technology changes, and obviously if you're not kept abreast with the technology, your marketability drastically decreases. ATMs, everyone knows how to use an ATM, not necessarily an exoneree. DVD players, think about just the advances in the computer. I think about it just during my lifetime and in my adulthood, and I can't keep up with it. So someone who's never touched a computer before and are completely illiterate with the internet are going to find themselves behind the 8 ball when there's a candidate, at least who knows how to turn on a computer. Also, there's some residual effects of a conviction that are extremely hurtful to an exoneree. And which also segue into them not being able to find employment, such as they'll always have a scarlet letter of a conviction. And a lot of these individuals, when they're spending a lot of time behind bars, obviously for more aggravated offenses, more heinous crimes, and so they will always have that scarlet letter. Most states do not have an automatic expungement, so again, going back to the interview process, and you may have someone who's sympathetic to the gap in your resume, but it's still on your record and you can't really explain why. And then it's also, it's going to say that crime. So it really puts them, again, behind the 8 ball. Also, just the cynical view of just the lack of forgiveness. Well, you may not have been bad when you went into prison, but you are certainly a bad person now, because no one comes out of prison as a person. You learned how to be bad, you had to toughen up, you became institutionalized, there's that stigma. And also, some individuals don't understand the difficult process that one has to go through to actually be exonerated, and they still have this feeling that you simply got off on a technicality. Those who actually work in the field, and they will be the first to tell you that there are no technicality exonerees. So there's this myth that exonerees, if someone can pour coffee or spill coffee on themselves and they can get a couple $1 million, well, certainly someone who was behind prison for many years is going to get a lot of money, and that cannot be further from the truth. These individuals, most of them are not receiving any compensation. Thankfully, that is decreasing, and more states are enacting compensation statutes. I believe when I started studying this, there were 16 states who currently had a statute, and by the time we pitched it to the legislature for the first time, there were 19 jurisdictions that had a statute. So it is an increasing movement, and I'm glad that Utah has decided to be a part of it. So really what happened is that I got mad, and I had to, and nothing really makes me mad except the grade system and exonerees, but anyways. I had to write a seminar paper anyways, and part of that seminar paper had to describe how can you fix the problem or how can you remedy the problem. And so obviously it didn't take much thought in my head, well, of course, the statute. So, but then I thought, well, if I already have to write this and I already have to research it, well, I know I'm not a very good writer, but I'm a really big pain in the butt. So I thought, well, great, I can just annoy these people up at the Hill until they listen to me and do what I want them to do. So that's basically where it started. I started with the Innocence Project model statute, and through our discussions in class and research, I was able to pinpoint a lot of the deficiencies in the statute, and I'll just highlight some of those. A lot of them don't provide for any health care or any meaningful compensation that would allow someone to obtain health care, mental health care services, etc. Also, many of them didn't differentiate between deaf inmates and non-deaf inmates. Ultimately, in our current statute, neither does Utah. But that was definitely something to think about and something definitely to bring to the table and discuss. Most of them, if not almost all of them, do not require an expungement of the record. There was one individual, his name was Vincent Moto, out of Pennsylvania. And they were trying, he was getting quoted $6,000 to expunge his record, and obviously someone who is making money by letting friends and family come over and use his washer and dryer is not really going to have $6,000 laying around. Attorney's fees, a lot of these didn't incorporate attorney's fees. Maybe some of these innocence projects are working pro bono and up until the point that they are released from prison. However, at that point, there's not really any organization or mechanism for them to receive assistance or help to integrate back into society or help them make their way through the court process, whether there is a statute or whether there isn't a statute. And some of these attorneys, terrible, want money. So none of the statutes really compensated for the attorneys. Also, there was some really pathetic, I can't even call it compensation or award. I did some math on the average, I think it's 12 years the average exoneree is behind bars, and I did some of the math, and some of it was down to $1.50 a day. I mean, pathetic. I think states should be embarrassed if that's what they're calling compensation statutes. Also, there were really short statute limitations. Some of these states you had to file within, 3 or 6 months of being released from prison. At that time, their number one concern is family, friends, food, shelter, that kind of thing, and it's not really an eager battle to get back into court. Also, state taxes are a big issue. A lot of these states, you know, when you receive an award, the states want their cut, which is funny because they just gave it to you. But so we made it very clear in our statute that the state cannot get their hands on it. Obviously, we can't do anything about the federal side, and this may not shock you, but I actually did contact some congressmen, and they were not eager at all to contact me back about, you know, keeping compensation separate, not taxing compensation federally. Also, this is a big, and I think we could spend an entire session just talking about false confessions and those individuals who plead guilty. Most of the compensation statutes do not allow for compensation under those situations. I think we all know that innocent people plead guilty all the time, whether it's you're risk adverse or looking at the evidence. And dear God, if you're in the federal system, what do you do? So, and then false confessions, as we know, studies show, and there's a phenomenon that innocent people really do confess, whether there's a hard hand in the questioning or improper questioning or insinuation, innocent people do falsely confess. So from there, after we put together a base bill, I contacted all the legislatures. I started bothering them, and then I started bothering Jinsey and Dan. And I took their entire summer. So, and Representative Littback, and I'll always be indebted to him, was nice enough to join me for a cup of coffee. And obviously, it's been a really long cup of coffee because he's still with us, and he's still in for the fight. He's been there all the way, even though there's been a lot of politics in which he'll talk about that has tried to stop us. So they received a copy of my seminar paper, they received a copy of the draft, and I pitched it as I'm a student, help me out, just listen to me, I'll smile and show my dimples, whatever I have to do, just give me 5 minutes of your time. And I was really shocked, a lot of them actually did it. So that's kind of how this started, was a word of mouth and just start educating. Mostly it started anecdotally. And we went from there and got into more of the legal aspects of why we actually need the statute in place and why the current mechanisms, such as what Jinsey was talking about, 1983 actions are just simply insufficient. So then we needed to get the public involved. We needed to explain how this really works. So we decided to show the Sundance film After Innocence. But at that time, it wasn't on DVD or anything like that. And when I called to see how much it would cost, they wanted $1,200. And I was like, crap, I'm broke. So we founded the Utah Law Innocence Association so that we could get money up from the University of Utah's Hill. And so we were up there till like midnight trying to get money. And really it just came down to beg, borrow, and I won't admit on camera that I stole, but anyways. So we also got a lot of donations. We were really happy about that, even donations out of New York. And we were able to raise enough money and convince Scott Hornoff to come and join our cause. And Scott Hornoff came out, and though he wasn't able to, Scott can't actually watch the film. I think it hits a little bit too close to home. He's depicted in the film. But he did come and speak and answered very candidly the audience's questions. And I think it was really, really helpful. We highlighted the fact that this was an invitation to legislators to come and figure out what is going on. A lot of our legislators aren't lawyers, so they necessarily aren't even thinking about this versus really don't have an idea of how difficult it is for these individuals. And the morning of that, in our local NPR station allowed us to come on, and they helped us pitch for the event as well, which I think really increased attendance. So as Creighton had described, we went up in 2006 with this terribly worded bill that I put together, and we ended up circling it, which is actually the best thing that ever happened to it. Although I did cry at the time, in hindsight, it was really great. It's now, there was a lot of concerns, and rightfully so, of very loose language as to who is actually innocent. And it was the language loose enough that maybe those who really are awful in technicality to get this compensation. So that was the idea, and that was our goal, to really only compensate those who were factually innocent. And so we tabled the bill, like Courtney said, established a committee. We met for several months. It was a great committee. I'm really honored that they let me hang along for the ride, because I certainly didn't have much to offer. These individuals work in this area every single day, but they let me see how good work is done. So, and this new bill, I truly believe could actually be a model for states who are looking to put together a compensation statute of their own. And I think we have strong reasons as to why this is probably the strongest bill in the country, so that they would have to do very little legwork. So I do hope that our bill will make it easier for other states to be able to enact legislation of their own. For example, we tried to really think, I think with a bunch of lawyers who work on this day in and day out, they really had a lot of foresight to be able to see the potential problems. So we went ahead and outlined stuff, the standard of proof, the types of evidence that can be used. For example, we can see it going all the way up to the Supreme Court, trying to figure out, is a defendant going to be allowed to use hearsay evidence? Or, little things like that will become issues that could last years. What type, obviously I said what types of evidence. Who is to make the findings, a judge or a jury? What's the standard of proof? And also make it more fair and more palatable. What if this individual was serving a concurrent sentence with a crime that they actually did commit and are factually guilty of? We didn't want to compensate those for those years in which the sentence was running concurrent. And also, what in the situation where someone was subsequently convicted of a crime? We met where that during that time that they were serving a sentence for a subsequent crime, they wouldn't receive compensation while they were in prison, but it would then again start when they were out. And most importantly, we said that this was going to be the end of the claims. That was really a very important aspect of the legislature, except in extraordinary circumstances. So if you were brutally beaten in prison and you are suffering long-term permanent disabilities, then you would be able to seek additional recourse in addition to the compensation that you would receive through the statute. And I think our backdrop to this was also to have consistent compensation. It shouldn't matter what color you are or how old you are, or most importantly, what everyone likes to talk about, what you were making before you went into prison. Fact is, a lot of these individuals are minorities, and it shouldn't matter what kind of publicity that your specific case received. Someone's freedom is equal to another person's freedom. So that was a consistent backdrop that we were working with. And then in 2007, Creighton was really instrumental from the AG's office to be able to speak to these legislators, because one of their main concerns that I think David will talk about was the fact that this was coming from the defense, and we're a bunch of bleeding heart liberals. They don't like it. So Creighton was able to come in and verify that this is a bipartisan issue. All of these groups have come together, and everyone is supporting this bill, and it really made a huge difference. And ultimately it passed in the House 64-8, I think. So it was a huge success. But before it passed in the House, and David will touch on this as well, they did want to strike out the entire compensation, and of course all of our hearts stopped and we said, what in the world do we do? So we circled real quick, we met, we had emergency meetings, we identified exactly who we'd be targeting, and we had to develop a pitch, and we did it rather quickly. We said, well, how heartstrings are obviously not working, the legal aspect is obviously not working, the morale aspect is obviously not working. Let's hit them where it hurts and let's go to their pocketbook. And so that's the theme that we really used. And so quickly, sitting in David's office one afternoon, we did a Google search and we started searching some of the awards, and we found 22 different, we were looking for awards that went out in states that did not have a compensation statute. And our first 22 we put into an Excel spreadsheet, and when we broke it down as to what would happen, because no state is immune from wrongful conviction. And we started crunching the numbers. We have 15 different jurisdictions, including Canada, and out of those 22, without a compensation statute, without Utah's compensation statute, say you could logically extrapolate these numbers and make them into Utah. This is what would happen in Utah, which is a stretch, I realize, but it's the best that we have. Only in 2 cases would the state actually pay out more money than what they received in their states through either special bills or suing in a tort action. And those savings were in one case was $10,000 and in another case only $40,000 for the state of Utah saved. However, in the other 20 cases that we found, and this was a complete random sample, the highest amount that Utah would have put out in, for this one, James Newsom from Illinois, he received a $15 million award for his time behind bars. Under Utah's statute, he would have only received $510,000 for savings of $14.5 million. Some of the legislators saw that, including me. So, and then it just went 20 other ones showing where, and we pitched it, hey Utah, this is an insurance policy for you. It's the best one you've got, and basically, if you need to do it,